Hello, everybody. This is Fair Housing Advocates, bringing to you as part of our education and outreach efforts a free fair housing webinar titled Disabled Military Veterans and Housing Discrimination, 10 Most Common Violations of the Fair Housing Act. These are the 10 most common that we see across the country in the states in which we operate. So what is the Federal Fair Housing Act? I think most people have an idea. Falling under the Civil Rights Act, but newspaper headlines, the purpose is to protect everyone's fundamental right to fair housing. Choices of where we live, whether to own a home, rent, regardless of factors called protected classes, such as your race, skin color, religion, sex, national origin, which is, if you're from another country, familial status, if you have children, and disability. So everyone should have the equal right to have housing, and then while you're actually housed, everyone should have equal access to everything on the property and all the services related to the property. That's what fair housing is. What's covered in the Fair Housing Act? Pretty much everything. I'll say this, other than short-term housing, so hotels, motels, so anything, what's not covered is non-permanent. There are other things that are not covered, but we're going to keep this webinar kind of streamlined. So this covers rentals, apartments, mobile home parks, condominiums, condo associations, single-family homes in a city, in a municipality, in a county, or those in a homeowners association, the sale of any kind of dwelling, lending, and of course it actually even covers a city, state, or a government that may have a rule or implement something that might be discriminatory. They can't run from the Fair Housing Act. The discriminatory effects standard, so I like to talk about this before we go further. Any of the things that I talked about today, intent is not a requirement. So HUD, U.S. Department of Housing and Urban Development, does not require that the complainant, you, the victim, prove that they intended to discriminate. Intent is not even a factor. As long as the effect is discriminatory, it's fair game with the Fair Housing Act. So here are the 10 most common discriminatory housing practices affecting disabled veterans that we see today from Fair Housing Advocates' perspective. And I put them in order of, how often we see each of these. So number one, refusal to provide reasonable accommodations for an emotional support animal. A lot of housing providers and a lot of other people think that there is a difference between an emotional support animal and a service animal when it comes to housing. When it comes to housing, there is not. When it comes to public accommodations, there are. But when it comes to fair housing, there is no difference. An assistance animal is not a pet. It's an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, or provides emotional support that alleviates one or more identified symptoms or effect of a person's disability. So an assistance animal is the umbrella term that we're going to use moving forward, covering emotional support animals and service animals. They are treated equally in the Fair Housing Act. One is not given priority over the other. Number two, back to number one, most housing providers refuse to admit or they don't understand that an emotional support animal and a service dog are the same, so they don't treat them the same when in fact they should. Number two, refusal to provide reasonable accommodations for a service animal based upon breed, weight, or size. Simply put, breed, size, and weight limitations may not be applied to an assistance animal. And remember, assistance animal is emotional support animal or service animal. Can't apply breed, size, or weight limitations, restrictions, fees, and things of that nature. Number three, making common areas and facilities unavailable to the disabled who require an assistance animal. So common areas and facilities, we're talking about like the swimming pool area, the clubhouse, the barbecue, area, the hot tub area, things like that. So to permit a person with a disability to live with and use an assistance animal in all areas of the premises where persons are normally allowed to go. Your assistance animal, emotional support animal, or service dog, right? That's what an assistance animal is. They're permitted to go with you anywhere that you would normally go. If the apartment complex would normally prohibit a resident from smoking on the rooftop, then you can't go there either, nor can your assistance animal. But certainly can go to the pool area, the hot tub area. Of course, your dog will not be going into the pool. Number 4, making common areas and facilities unavailable to the disabled without assistance animals. So we see a lot of cases where maybe a disabled person, maybe there's a rule written right on the wall. It says disabled persons cannot use the hot tub without other, I don't know, adults around for safety reasons. We've seen that for safety reasons. Okay, so you're basically, if a disabled person, and a disabled person could be someone who has a physical injury or someone who has post-traumatic stress syndrome. And so why would you prohibit someone who is disabled in that regard from using the hot tub? So there is no difference. You're prohibiting them from using the hot tub on the basis of disability. That is discrimination. Charging pet fees, pet rent, and pet deposits to assistance animals. This is an easy one. You cannot charge a pet fee, pet rent, or pet deposit to any assistance animal, service dog, emotional support animal. Very, very easy. If this is happening to you in any way whatsoever, you must contact us. We will help. No cost. We are a nonprofit fair housing organization. Requiring service dog registration or a service dog certificate, and I always see service dog registration, service dog certificate, or some proof of training, right, to review an accommodation request. None of those are required by law. It's the U.S. Department of HUD's position that animals that are necessary as reasonable accommodation do not necessarily need to be trained or meet certification requirements. This is consistent with HUD ALJ decisions, HUD handbooks, and Office Public and Indian Housing. So I see a lot of housing providers requiring, I need a service dog certificate. I need proof that it's registered as a service dog. None of that is legal. None of that is even reliable. Number 7, segregation of the disabled from the resident community. And obviously segregation is illegal. I think anyone listening or watching this would understand that you cannot segregate on the basis of your protected class, race, religion, so on and so forth. But we see this often with disabled persons. If you have a wheelchair or a scooter, they don't want you living on the 2nd, 3rd, or 4th floor. Maybe they feel it's too loud. You do the same thing with disabled persons who have assistance animals. We don't want those dogs on the 2nd, 3rd, or 4th floor. It makes it loud for the tenant below. You have to live on the 1st floor. You have to live in prescribed units. All of that is segregation, and all of that is illegal under the Fair Housing Act. Refusal to provide a reasonable accommodation, non-assistance animal related. So let's say you don't have an assistance animal. We see a lot of cases where, for example, someone may need a handicap parking spot closer to their residence, their apartment unit, let's say, or a handicap parking spot closer to the community pool at the homeowners association, right? You live in a gated neighborhood. If someone has a very serious lung condition or a physical disability and they can't walk more than 30, 40, 50 yards, and it's very difficult for them to get, if they park far away from the home or let's say the swimming pool area and they can't get to it, then you are making it unavailable to them. You have to make it available to them. The way you make that available to them is to provide let's say a handicap parking spot. That would be an accommodation request. That would be very reasonable. To deny that would be denying the facilities to the disabled person when other non-disabled persons have access to those same facilities. Number 9, refusal to permit an assistance animal due to insurance reasons was very popular, becoming less popular, seeing a little bit of a resurgence, especially in those towns where pit bulls are perhaps banned, which reminds me, a housing provider cannot, because they live in a city that perhaps bans a certain breed, let's say Doberman Pinschers, pit bulls, they can't apply that pit bull ban to their housing, to their properties, the apartment complex. And if they claim it's an insurance issue, the insurance company will drop their coverage. That is no longer a really valid defense anymore. It's 2016, almost 2017, and pretty much any housing provider can find comparable insurance without the restriction available out there on the market because of the internet. So where it may have been a defense years ago, not going to be a defense much anymore. Number 10, requiring interaction with a disabled person's medical professional to verify a disability. Simple. Housing provider may not ask an applicant or tenant to provide access to medical records or medical providers, or provide detailed or extensive information or documentation of a person's physical or mental impairments. If you already have a letter written from a reliable source, could be a licensed clinical social worker, could be your doctor, and that letter verifies your disability and verifies your disability-related need for your assistance animal, could be emotional support animal, could be service dog, doesn't matter. That's all that you need. You do not need to, if you've already provided them with that, or maybe you have it and then you do provide it to them, the housing provider that is, that housing provider and landlord property management firm cannot ask you, hey, can we talk to your doctor? We want to talk to your doctor. We have to email something or fax something to your doctor to verify your disability. They cannot do that. They cannot interact with your medical professional, nor ask for, obviously, things from your file. That letter should stand on its own. So if any of the preceding discriminatory housing practices have affected you, the disabled person, or maybe someone in your family who might be disabled, these may be fair housing violations. Most of them are. Most people perceive them to be a landlord and tenant issue. It is not. These become civil rights issues, easily handled by the United States Department of Housing and Urban Development. It is a federal issue. Here at Fair Housing Advocates, my firm, my organization, we can help you. We are a nonprofit fair housing organization. We are committed to ensuring that all people of any protected class are provided equal housing opportunity. We are currently on the Patriot Project. We have seen over the past so many years that a lot of our returning military veterans and active duty as well as those who have served us in law enforcement, first responders, our firefighters, EMS, that a lot of them whom are disabled, maybe that a lot of them suffer from post-traumatic stress disorder, which is a disability that's not readily apparent. You can't tell by looking at someone that they're suffering from PTSD, but that segment of our society, we call them our patriots, our military, law enforcement, and first responders. We're seeing that they're victimized by housing discrimination, as a lot of them do have maybe a disability that's not readily apparent, and the housing provider doesn't understand how to accommodate a disabled person who has psychological or emotional disability. Maybe they require an emotional support animal or a service dog. We're there to help you. There is no charge for what we do. We are a nonprofit fair housing organization. We operate everywhere across the country. There's no cost to anyone that we help. We write the complaint. We can help you file the complaint. We can negotiate the complaint settlement for you. We help develop evidence that you may need to support your complaint. And we work with the U.S. Department of Housing and Urban Development, called HUD, on your behalf to negotiate something or to negotiate a settlement that makes sense for you. And we work with U.S. Department of HUD throughout the investigative process. We offer no-cost, advocacy, counseling, referral services, education, which is what we're doing right now, of course, outreach, and even fair housing training for you, anyone in your family, any veterans organization, any service dog organization, any one of your organizations that could benefit by using our services. If any of the above that I've mentioned in this PowerPoint presentation rings a bell, any of these violations hit close to home, please reach us. You can learn a lot more about us at fairhousingact.org. You can also email us at info@fairhousingact.org. And you can also reach us by telephone whenever you want. Our consultation is always free. Everything we do is no cost. We are more than happy to help you protect and establish your fair housing rights. Look forward to hearing from you if you need our help.